Schulte.
Thanks, Your Honor. Ladies and gentlemen, this is my turn to talk to you a little bit about my thoughts about what we've heard in the last 2 days. And this is my only chance to talk to you about that. And again, the reason is very simple. Mr. Smith gets 2 bites of the apple because he has the burden of proof. Because the law makes it so difficult for him to prove beyond a reasonable doubt the allegations that have been made, he gets two shots at you to try to do that. This is the last time that I get to talk to you, give you some of my thoughts about what you have maybe heard for the last day and a half to 2 days. And I think the first thing I want to do is get right back to what I very first said. It's very easy to accuse someone of something. It's very easy. All you have to do is do it. And then the investigators from the state take over and go from there. Now, in Scott's case, what happened apparently was an accusation was made. So he's at lunch in his home, and squad cars pull up outside his house. I don't know whether lights were flashing or not, doesn't matter. But basically, they take him into custody. He has no idea what's going on. They take him down and they put him in this very small room. You saw it on the videotape. I've been there many times. Not as a defendant, but I've been there many times. And it's a very small room. You know, you're on candid camera. You don't know that, but you are. And they interview him. Now he's given some idea of what they're there to interview him for. You didn't see the part that we deleted, partly so the thing wouldn't be so long. But they spent quite a bit of time giving him what we call the Miranda rights. You know, you have the right to remain silent, which if any of you ever get in any kind of trouble with the law enforcement, I suggest you do. You have the right to have a lawyer, which people really need to listen to because that's a very important right at that point in a situation. But that was not shown. But he's got some idea that something's wrong because he says, "Am I under arrest?" And as he stated, they said, "Well, no, but you can't leave." Well, I don't know exactly when you're under arrest, but when you can't leave, that sort of sounds like it. So he's getting some indication that, you know, he's not here for a pleasant chat. So he figures out, and they indicate that his niece, Kayla, has made some allegations. And Mr. Smith thinks it's extremely telling that he immediately says she was 18 when it happened. And I think that is very telling. Because the first thing that he thought of when he hears that she has possibly accused him of something is that she was 18. He's thinking of the kiss on the road with the broken tire. That's the first thing that pops into his mind. He has admitted to that. He knows that was wrong. He is ashamed of that. And that's the first thing that popped into his mind. Later, as they go on, well, there have been other things, and do you do this, and do you do that? Well, maybe while we were cuddling. Now, I'm not sure that I understood from his testimony, or anybody's testimony, what he thinks cuddling is. But as I understand, he's talking about being in this John boat. And the cuddling apparently is they're touching each other back to back because he's wrapped around an area where there is a heater that he's protecting during the night while everyone is sleeping. Either way you look at it, you can look at it from his point of view or from somebody else's point of view. And if you listen to what he was saying, I was trying to explain away the fact that we had this kissing incident that happened out on the road when, incidentally, she had gone out of her way to call him and asked him for help with the tire. Despite the fact that he had to travel a great distance, he put himself out to help this gal out. So he's confused about what's going on as he sits in this little room in the sheriff's office. The next thing I want you to consider is exactly what Mr. Smith just got done saying. People don't commit sex abuse in front of other people. People don't commit sex acts, legitimate, normal sex acts in front of other people. I think they have a tendency to do it in private, to take it to a bedroom, to take it to someplace where no one else is around. And then you have a sex act. In each instance where she says they had a sexual contact incident, there are all these other people around. Next, we get to what is he actually accused of by this trial information, and what is it your duty to find him either guilty or not guilty of. It's one incident in the living room, watching television, at a time when she may have been 15 rather than 16. In a living room with two parts of the family at least present, in a room that I believe she said was something like 20 by 12, on a couch where there is possibly as many as 3, maybe 4 people, again, if one of the kids jumps up there. The testimony from Scott's wife is that there's no blanket on the couch. She keeps the blanket over in the chair because she's cold all the time. Kayla's mother had a blanket because she is uncomfortable in the air conditioning. Scott never said anything about ever having a blanket. Scott's brother-in-law, Randy, was on the other end of the couch, and different people apparently came and go in the middle section. But how do you have an illicit sexual contact in a room full of other people? Who would even want to do that? You get people alone, and then you perform your sex act. So Mr. Smith is right. In most of the cases, all of the cases we deal with, it's done privately. It's done hidden away. Now, other scenarios have been talked about, things that happen after the alleged sex act that we're talking about on the couch, in front of all the people, watching television or NASCAR races or whatever we're doing. All these other scenarios are not what you are to concern yourself with. You have a jury instruction that just told you that. They're just to sort of show, well, if you believe them, then you can say, well, yeah, he must have had a particular passion for this girl. If you believe them, I guess you can think that. But that's not where you're to find him guilty or not guilty of. We're talking about only this incident on the couch. At a time when the state says they have proved that she was 15. Even there, there's some wiggle room. Because remember, under oath, in deposition, she testified to the question, well, how old were you? Well, let's see, it was 9 or 10 years ago. Well, if you use math, you come up with 15 or 16, so I asked her, so 15 or 16? She goes, yeah. Proof beyond a reasonable doubt of every single element. Everything that has to be proven here beyond a reasonable doubt. The judge gave you an instruction, and the instruction says, reasonable doubt is the kind of doubt, it's important doubt. It's the kind of doubt that makes you hesitate before you do something important. There are doubts which are not reasonable. I mean, we see them every day, we can think about them. I think one comes to mind. I can remember thinking about reasonable doubt. A few years back there was this, I think it was some kind of preacher from maybe Florida or something. And he came up with this theory, or there was this theory running around that the Aztec calendar was running out. I don't know whether any of you remember that, but I think it was December 21st, 2012, the world was supposed to come to an end. And they put billboards up all over the country, and there were people getting really quite upset about that. Well, if you think about it, if you go to sleep on December 20th, 2012, and there's all this hoopla out there that the world's going to end before you wake up, I guess, you know, I got some doubt the world's going to be there tomorrow. Now, is that doubt reasonable enough so that I decide not to set my alarm clock, since I don't have to go to work tomorrow anyway, because there's going to be no world? No. I set my alarm clock. I sort of fully expect that what would happen in the morning is what happens every morning. I wake up and I'm still here, the world's still here, and the sun has come up, and there's things I got to go do. So thinking that the world wasn't, doubting that the world was going to be there the next morning, that's not a reasonable doubt. But a reasonable doubt is a kind of doubt that is serious. You know, if you are convinced of something, you don't have reasonable doubt. If you are abidingly convinced of something, you don't have a reasonable doubt. When do you have a reasonable doubt? Well, you look at all the evidence here, all of the evidence, and you say to yourself, you know what? I think he might have done that. Then you have a reasonable doubt, and your verdict must be not guilty. Goes a little bit further than that. You think about all the evidence, you think about everything you've heard, and you think, you know what? I think he probably did that. Then you have a reasonable doubt, and your verdict must be not guilty. If you look at it all and you say, yeah, I'm absolutely convinced, I'm sure, I'm dead bang sure that he did it, you don't have any more reasonable doubt. But that's how sure you have to be before you can come up with a guilty verdict in this case, or in any criminal case. I think that if you look at the testimony, some of it's confusing. Confusing testimony leads to reasonable doubt. I think if you look at all of the testimony, some of it is inconsistent. Inconsistent testimony leads to reasonable doubt. And I think if you look at the bulk of the testimony from the state, so much of it just doesn't make common sense to us. Just goes against what we think the way things really are, that we've always observed, that we've noticed in our experience in day-to-day. I think if you look at it that way, that's reasonable doubt. I suggest to you that the state has not, at this point, proven every element of this crime beyond a reasonable doubt, and I ask you to enter a verdict of not guilty accordingly. I thank you for your time. I've got to turn it over to Mr. Smith now because I'm done. Thank you.
Thank you, Mr. Schulte.